All right, folks, buckle up. We're diving straight into a DUI case that's about to take a few sharp turns. 2 new charges are being added here, and trust me, this courtroom's about to get interesting.
Obstructing attempt, the 1-year offense. On our successful plea to that, those charges, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Has she signed an advice of rights form?
She did. Should be in the file. Who did the last time we were here?
First one.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
To
State your name.
Cynthia Lakefair.
All right.
Notice how calm Cynthia sounds here?
Court
That's
could order
the
your
tone of
vehicle
someone who knows
immobilized.
this
Could
isn't
order
their
you
first rough
to pay
morning.
the cost of the
But the law
prosecution
doesn't
as well as
care
cost
how
of any
polite you
emergency
sound once
governmental
your BAC
services. You
says
understand?
otherwise.
Ma'am, it is this court's understanding that you are going to be pleading guilty to 2 charges. Is that your understanding?
Yes.
While intoxicated, that's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Yes, sir.
All right. Count 4 is the charge of attempted resisting and obstructing an officer. That's a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court. You understand that?
Yes, sir.
All right. Now, understanding all of that, you still wish to plead guilty?
Yes, sir.
To the charge of operating while intoxicated, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct?
Yes.
Any questions?
That guilty right there seals the deal. No trial, no debate, she's admitting to it. And that means sentencing power shifts entirely to the judge. It's like handing the steering wheel over right after a crash.
Regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a
Yes, sir.
January 18, 2025, at the location of 9876 Main Street, Whitmore Lake, Northfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
What'd you have and how much?
Captain and Coke at Captain Joe's. I don't remember. Maybe.
All right. Were you stopped by the police or was there an accident?
There was a single car rollover accident, Your Honor.
Okay. Did the police arrive?
Yes.
Were you taken to the hospital?
Yes.
Was there a blood draw?
Yes.
And what were the results of the blood draw?
It was .253, Your Honor.
Ma'am, do you have any reason to dispute those blood test results?
No, sir.
All right. When the police did arrive and you were interacting with the police, what happened?
Did you attempt to kick one of the police officers?
Yes.
And at the time that you were attempting to kick the police officers, what were they trying to do?
Take me into the hospital.
They were trying to get you into the hospital, get help for you, and you tried to kick them. Is that correct?
Yes, sir.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed pursuant to the plea agreement. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
16th at 9 a.m.
Whoa. .253. That's over 3 times the legal limit in Michigan. To put that in perspective, that's the difference between buzzed and barely standing. This wasn't a close call. This was a full-on blackout level BAC.
June 16, 2025, 9
Yes.
9 a.m. before Judge Freshour. Bond will continue.
Not regarding bond.
Yes.
There is a key corrections report, maybe slightly turning. How I read it, there was a missed test in the evening, and then the following morning, the late test with a very low alcohol, 0.006, I believe, which
What happened? I don't know why they didn't say this is a violation of a progress report.
I had just received the,
Mr. Allen, on April 11th, you tested positive for alcohol.
Your Honor, this was the first time she's ever been on any type of SoberLink monitor. It's the first time she's ever had a criminal offense. And this was the very first day. You can see she missed the test on the night of the 10th, which is the same day she picked up the SoberLink, and then she missed the next morning, or tested positive the next morning in the 5 to 8 window the next morning. I believe it was just a process of her getting used to being tested.
I don't know what that means.
It means that alcohol is the undisputed heavyweight champion of the world. If she was drinking prior to that date, she had quit, and she may have still had some residue left over. She has had no positive tests since the first day of testing. And if she hasn't figured out a way to stop drinking successfully, she is going to be found out when she's either continuing on bond or when she's on probation. And we would have no objection to her continuing on the SoberLink as long as Judge Freshour thinks necessary.
Well,
Here's where it gets tricky. The SoberLink device, it's like a breathalyzer you carry with you. Think of it as a parole officer in your pocket. And missing even one test can raise serious red flags.
except for the fact that I have an arraignment occurring in January 2025. Unless that date is wrong.
There was she was doing testing, random testing every week for 3 or 4 months, but there was no alcohol testing, regular alcohol testing. There was no SoberLink. There was no scram tether. There was nothing for 3 months.
Yeah, but she was under an order not to consume alcohol.
I understand, Your Honor, and I'm not saying that she did. I'm saying that it looks like this was her first time ever on a SoberLink, and maybe it takes her a while or took her one day to realize what the expectations were, and she cannot have any alcohol of any kind to consume anything that would possibly cause a positive reading.
It was at this moment that she knew. She fucked up.
She knows she's not supposed to have alcohol.
I did not. I had a root canal. I was in the process of that. Only thing I had was penicillin. Honest to God.
Really?
I have
Is that what you really want to tell me?
I'm telling you that
If
honest
you're,
to God.
no, ma'am, is what you want to tell me is that on April 11th, you tested positive on a SoberLink because of a root canal.
I had no alcohol.
I've been doing this a minute.
I had
If
no
that's what you
alcohol.
want to tell me. Ma'am, I'm just asking you a straightforward question. Is that what you want to tell me?
Yes, sir.
Okay. Well, then I'm going to let Judge Freshour handle her bond, but at this point, her bond is revoked. Defendants remain.
Thank you, Your Honor.
When I'm done with this document, clear the court.
Yeah, I didn't know.
Can we get another date prior to
You want another round?
Well, I want another date prior to the
You want to
June.
still mess with me?
I want her to.
What? You know, I'd like to.
You and I are on
Now, no. What? Go ahead. What?
You and I are on the same. You and I are on the same page.
Yes.
And actually, I asked Andrew to have her tested, deep testing. She's going to be really mad when she hears that, but I don't care.
Do I have an interest?
It's May 19th at 9 a.m.
May 19th.
Yeah, I think that's good. Thank you, Your Honor.
And there it is, the moment of realization. You can almost feel the tension drop. Every judge knows this excuse, the classic medical procedure defense. But spoiler, it rarely flies.